Good. All right, guys, let's get right into this video. Attorney Walter Hnot here. Now, here's a quick update. Obviously, like, subscribe, membership in, and let's get going with this. Now, the purpose of this video is to examine a Chief Judge Bulletin released originally on 7/19/23 from the Office of the Chief Administrative Law Judge. So just to clarify, this is a high-up adjudicator in the machine of the Social Security Administration. This is a notice I should have done a video on earlier, but its timing is really interesting because it was at the middle end of last year. And it tells us exactly where the SSA is at, specifically when it comes to dealing with congressional inquiries into your claim or your issue when it comes to your interaction with the SSA. So let's say a problem happens, you reach out to a congressperson, right? So you get your House, you get your senators, stuff like that. You get one of them to write a letter to the SSA, a congressional inquiry sort of deal. When you do that, this notification, Judge Bulletin, is basically all about that. Now, there are some things that you need to keep in mind before we really get this video kicked off. There are some things that you need to keep in mind that are extremely relevant to going forward and understanding why this is so relevant. Let's go through real quick. Some questions. Does Congress need to hear you when the SSA wrongs you? That's a question. Next question. Who are the best people to decide if a case needs to be expedited or some variance with the rule sought to fix a harm imposed by the SSA's administering of your processing? Let me read it again because it's a little bit complicated. Who are the best people to decide if a case needs to be expedited or fixed or changed or modified, right? Who do we choose at the SSA to figure out the solution? Or some variance of a solution where they go off of the rules that they normally use to fix a harm imposed by the SSA's administering of your benefits, administering of the processing of your claim, right? Cool. Another question. Is Congress doing its job when asking questions of the SSA, and are highly intelligent, doctorate-level brains reviewing these questions? Now, I need you to understand one very important particular item when we talk about this. It is extremely important. I need you to understand it because it doesn't feel good when you think about it. Okay, it doesn't feel good. So, people who are doctorate level, okay, they have a doctorate, right? And I don't mean the cute PhD people in some history topic. You pop those out left and right, okay? I mean in the sciences, the maths, right? Or the professional degrees, which are like your doctors and your lawyers, who constantly view themselves as never being enough, okay? Highly insecure people are almost always come in high intelligence fashion, okay? And the reason why is they basically know of a lot of little gray areas, little additions that could be added, but there's all these things that they don't know, and they don't know how to get to all of them. Some of them they do, they don't have time to get to them. They run through these analytical intellectual games because they can't find the direct solution. But somebody with a lower IQ, it's easy. There's no gray room. It's black and white. You got option A, you got option B. So the higher intelligence folks, they tend to have an inferior issue, right? They feel like they can't go ahead and be enough. And as a result of this, it tends to breed the attempt by these high IQ people of creating a persona that is like godlike, like, oh, I can do this, I can do that, stuff like that. But this video isn't about that. The point that I'm getting at is that a doctorate level person will usually become friends with non-doctorate level individuals. Okay. Again, this is not something that's going to make you feel good. This is something where I just need you to understand the difference between doctorate level and maybe somebody who just finished high school. Okay. So what happens is this. A doctorate individual will become friends with a non-doctorate individual. Let's say a high school graduate. That happens all the time. It's a beautiful thing. It's the way it is. It's the way it should be. And it's awesome that it happens. But the non-doctorate level individuals who hang out with the higher intelligence, higher intellectual quotient individuals, they have the opposite effect of this, feeling inferior kind of situation. Being that they will usually think that they're at the same cognitive level, the same cognitive normative standard as the doctorate level person that they hang out with, right? They usually do this for a lot of reasons. Sometimes it can be insecurity. This is because they are usually seeking shared ground, and they enjoy the feeling of, an enlightened stance. The point is, nobody's equal. Okay, we all know that nobody is equal, unless it's, of course, a kindergarten teacher telling the youth of a theoretical impossibility. Right? And inherent in that, we create laws to govern all levels of mental functioning, and we have jobs that serve different levels of intellectual functioning. As long as we can be adults and understand that not so feel good truth, okay? And understand that when you want something done, right? If you want something done, you want the person who has the most power, which usually is the person, unless we're talking about politics, which usually is the person with the most intelligence or the most experience in the topic, right? I know some of you will say, what the hell, man? I'm just as smart as my friend who went on to get a degree in, advanced particle physics. But remember, the more simple your mind is, the fewer the options in gray room in between the connective thoughts that render action. Okay? So the point being, if we just acknowledge an uncomfortable truth that not all people are equal, that some people have more upstairs in their brain power, and that we want them on the claim in the SSA figuring out a solution when a problem pops up, then we are on the right track. Because when you have a problem and you reach out to a congressional individual, House rep, senator, whatever, you expect that person with their authority to reach out to the SSA and have it have some effect so that somebody high up with a higher level of intelligence, usually a doctorate, will read it, review, any particular oddities, flags that are inside the system, and then respond and give, basically details that are needed to fix the overall situation or have a timeline plan that will fix the situation. Now we move to the SSA Bulletin. Bulletin CJB 23-03. Again, CJB 23-03. This is the Chief Judge Bulletin, specifically from the Office of the Chief Administrative Law Judge. Now, just to be clear, this is a high-level adjudicator. It's a high-level person. He's a person that makes decisions on behalf of the adjudication process relevant to essentially all those judges that you go in front of when seeking disability benefits. Okay. All right, here we go. Descriptive summary. We are issuing this Chief Bulletin, CJB, pending revisions to HALEX I-1-6-1 to document our new policy allowing all members of Hearings Operations Management to sign responses to congressional inquiries. Okay, so just simplifying, they're changing the rules. The new rule is, that other people than the top adjudicator are likely now to be able to go ahead and sign off on documentation, correspondence with the senators and the House reps when it comes to questions brought before the actual court system about claims where there might be a problem. All right, cool. After the Hearings and Case Processing System, HACPS, release on July 22nd, 2023, staff will be able to prepare responses to congressional inquiries in HACPS. Currently, HALEX I-1-6-1 requires either an administrative law judge, right, those are the ones you go in front of for your hearing for disability benefits, right, or a hearing office administrative law judge to sign the letter. Okay, so that's the important part. This is the important part where you have to realize what they're doing here. So in 7/9/23, the Chief Administrative Law Judge, as part of a Chief Bulletin, released a change in the rules saying, we don't want all of our judges to get bogged down with all of these, somebody reached out to the senator, somebody reached out to their House rep, and the House rep and the senator then went, back to the SSA and letter after letter after letter. When are you going to speed up? What's the answer to this question? How do we deal with this thing? What's going on? They have automated responses to congressional inquiries as a part of their HACPS, which is their hearings and case processing system, to just respond automatically to those, information requests from the actual congressional leaders. So when people always ask me, does it help to reach out to a congressional person? It's good to let them know you're pissed about the SSA, but the effect of them reaching out to the SSA is almost moot. It's not effective. It's just not. And the way it works is you reach out to Congress. Congress then reaches out to the SSA. SSA gives them boiler response back with some basic details. Those basic details then get shot back to you in a letter from the congressman or congresswoman. And then they say, okay, we'll update you when they update us. Cool. Then the SSA puts it in their system to send out an update 3 months, 6 months, whatever down the line. And then that update goes basically to the judge, that update then basically goes from, the SSA to the actual congressman or congresswoman. And then they forward that update to you. And when they forward that update to you, they also put in there, hey, there's nothing wrong with this claim. No problems, no issues that we see. We're going to go ahead and close the file on it. Let us know if anything else pops up and we'll go from there. That's what happens. Okay. Now, what they're saying here is in HACPS, any member of HO management may sign these letters, and we are in the process of updating HALEX to be consistent with this change. So now they're saying instead of having a high-level doctorate judge, right, go ahead. They've all got, at this point, for the most part that I know, law degrees, right, professional doctorates, right? So what they're saying now is that in order to go ahead and respond to these congressional inquiries, we don't need a judge anymore. They're just going to use basically HO management staff, which is the hearing office, using their HACPS template forms to just send off a response, send off a response, send off a response. They don't want a judge to have to spend time signing off on it. You got a problem, you talk to a congressional leader, it goes to the SSA, they're just using a template form, HO management's going to sign off on it, boom, done, back to the congressional office notifies you, and then you sit for 3 to 6 months for the next update. That's what's going on here. That's the new feature, that's the rollout of having Congress try to change the outcome, speed claim for the SSA. Please direct all program-related and technical questions to your regional office, support staff, yada, 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 so on and so forth. All right. So why is this important in a theoretical standpoint when it comes to the future of the SSA? The SSA got overloaded with lots of people reaching out to senators and House reps about why their disability claim was taking so long. The answer as to why it's taking so long, that they would never repeat, is that Republicans have no intent on funding the SSA to have enough money to actually process benefits as they should. And Democrats have been promoting and pumping through the news waves to tax the rich on a tax that will never get passed because you're taxing the rich 16 to 17% more on any income they have. So on $35 million worth of income that a rich person might have for the year, you're asking them to pay around another $5 million in taxes. It ain't never going to happen because the rich pay for the politicians to get elected. It ain't never going to happen. The Democrats know this. The Republicans know this. It's a stall tactic. Okay, so what does this mean? It means, very simply put, that the SSA now sees Congress interacting with it on behalf of your benefits as more of a template response system. It's all automated. Why? Because everybody kept reaching out to basically get a senator to help them go ahead and get a solution to the problem at hand. Why? Well, the reason this is all happening is because we are in the early stages of the Social Security Administration going through different minor to major collapses. We are in a collapse right now. We are in what's called the SSA's timeline collapse, right? Because, basically you are waiting obnoxiously long periods of time to get them on the phone, obnoxiously long amounts of time to go ahead and get a claim adjudicated, Makes sense, right? Makes sense. Okay. So with that said, now that you are on board with that and you understand that, what the future will look like is that when you have a problem, you can only rely on so many types of people to fix a lot of these problems with the SSA. The tougher the problem, the higher the level of intelligence you have to get to go ahead and fix it. You might need a judge to fix it. You might need a lawyer to fix it. You might need, basically somebody in the executive staff at the SSA. You might need a senator. You might need a House rep, although obviously the House reps tend to have a lower education stance than, of course, the senators. And education doesn't always equate to intellectual quotient. It's just, there is obviously a line where if you're taking tests and somebody else is taking tests, one person continues upward and the other person hits a spot and that's it. They hit this and they plateau off. So the point was the SSA on that date, the chief judge on 7/19/23 is saying to the American people, hey, we don't have enough judges to answer all these, questions from House reps and senators about why you're unhappy. And you know what? We're not going to make our judges figure out what the problem is. And you know what? We're not going to have them sign off on answering the problem in response to the senators and House reps. And you know what? We're going to create a template system, and then we're going to give field office management the okay to auto sign off on those response letters to Congress as a result of their congressional inquiries because you reached out to them. And you know what? This separates the people who can fix a problem from the people who have a problem. Now, what is the ultimate outcome of this? Okay, we're going to keep this video short. The ultimate outcome is that if you have a problem and it requires Congress to step in, the likelihood that somebody with the mental capacity and also the position, the judges, to figure it out, decide it, make it happen, it's just not going to happen. It's not going to happen. You're going to have to file a suit, right? Make it to the administrative law judge hearing stage, get it denied, go to appeals. You're going to have to go in front of the judge at that level and, hopefully have some sort of success with it as a part of some sort of hearing. But if you want to get answers before that, or even after the hearing, it's not going to happen. Because they're just going to have a field office manager a hearing office manager go ahead and auto sign it, auto templatize it, send it out the door, get it back to the claimant, make the claimant feel good. Now, what this means for the average person that's having an issue is that they are losing some of the best pieces of the puzzle of getting a solution. Now, it's no surprise to a lot of you that Social Security disability attorneys are not happy with the industry. Okay, it's been so bad that many of them are, retiring, getting out of the business, going to other things. Right? Some of the people who also have YouTube channels literally have switched away from Social Security benefits to, bankruptcy, to personal injury, to real estate law, whatever. They're transitioning away from this field because of the issues that they've seen, the issues that are popping up. In fact, you'll notice here. I'll pull it up right now. Social Security lawyer fee increase because the disability attorneys were getting paid so little. So yeah, it's going from $7,200 up to $9,200 effective November 30th, 2024. Why? Well, this is happening because the disability attorneys in this field make so little per claim that it doesn't make sense to represent most types of people who are disabled. You ever think about that? The price that they give to the attorneys is literally so low in this field that the attorneys won't work on the most needy people's claims because they can't afford too many losses in a numbers game field. Just think about that. Think about shaping an industry. The Social Security Administration is in charge of the attorney's fees, right? And the attorney's fees were so low. They were $6,000, then they got bumped up to $7,200. Now they're getting bumped up to $9,200. Okay, they were so low that many of our homeless, low-income SSI individuals, supplemental security income, could not get representation. Kids couldn't get representation, right? People under 50 couldn't get representation. Why? It's because the fee that we get paid on the ones that we win was so low that we wouldn't have enough money to take the risk of working on claims for the less likely to be approved, or even the medium likely to be approved. That then changed the culture of the SSA, having more and more SSI people not represented, which decreased the SSI people and people under 50 from being found disabled by 3 times as much. That's a scary thought right there. So just take that in for a moment. People over 50 that attorneys sign on to work with were 3 times more likely via their attorney to be found disabled than those other people who attorneys can't take a risk on. Now, I took a risk on many of them for a very long time. What changed all that? Why are we not taking a lot of people in their 40s, 30s, teenagers, 20s, stuff like that? Why are we not taking them anymore? We can't afford to take the gray room claims like we used to because the economy is so bad. It costs 2 to 3 times as much just over a 2-year period to buy the same products and services that we used to be able to buy. I know some people don't want to hear that because of their political alliance, and I mean, it's an alliance. They are deep into that. And I get it. Like there's some amazing things the Democratic Party does, but the economy is not one of them. And unfortunately, it's small businesses are going out of business left and right. It's just a sad fact of the reality because the costs of doing the business are too high. Payroll's high. Okay. You got to pay people more now. Buying stuff, paper, products, materials that we then make into other stuff. It's just too expensive. So the culture of what's interesting here is we're seeing figures, we're seeing judges go ahead and say, you know what, we're going to take away the higher knowledge, the higher capacity individuals. Okay, we're going to take away those higher level judges from signing off on something and give it to lower level staff, because we don't want them to get all clogged up with this, which means that you lost high-level brains, adjudicators, professional doctorate level people actually looking at a problem that you have because a senator or House rep agreed with you or at least agreed to look into it. And now you're basically stuck with the more aggressive actual adjudication process. Filing, reconsideration, ALJ hearing, appeals council, district court, circuit court, Supreme Court of the United States. Okay. So the thing is this. Oh, I see a message here. Anna Warner said attorneys in Ohio get 20% of winning of the case. So a lot of you guys don't actually know how attorneys get paid. And I should do a video on it because I haven't done it. Well, I haven't really done a whole video on it. The next video I'm going to be doing that's specific about code is about when you should go ahead and do expedited reinstatements versus basically new filings. Okay. And that's because this lady called me up. I don't know if I was snippy. I think I was just hungry and I was being fast because I had a ton of calls to get through, and she got upset and she just hung up on me. The point is I'm going to do a video on that and I'll kind of explain to you guys how that stuff works. But the point is this: attorneys get paid 25% up to $7,200 per claim. Once that claim gets denied at the ALJ hearing level and goes to appeals council, right? The next judge is up, the AAJs above the ALJs. Then the fee maximum, right? $7,200. The fee maximum, the $7,200 gets dropped at that point. Okay. Then basically, if you go up to district court, then you have what's called EJA fees, right? You got Part A, Part B, stuff like that. Okay. Equal access to justice, right? All right. And then if you get a remand, right, SSA decides it, then the SSA goes ahead and, pays you and yada, yada. Point is, right, I need to do a video on it because a lot of people, and that's true. A lot of people are like, I thought the SSA just pays them 25%. No, there's all these steps and limits at each step and changes in each step. There's all these things. But again, it is what it is. It is what it is. The only way people know is if we make these videos, we tell them, we show them what the actual rules are and go from there. All right. Now, so Mark Murphy said it's percentage of 25% of the back pay, whichever is less. Well, it's technically 25% of the back pay plus the retroactive benefits, if there are retroactive benefits to be payable for the claim, because retroactive benefits are the benefits that come before you actually file. So you file, you're found disabled, retroactive benefits, back pay benefits, forward pay benefits, right? Okay, cool. So the point is, attorneys get paid from retro and back pay benefits. It's 25% up to the maximum $7,200, unless they go to appeals counsel, in which case the cap is removed at $7,200 is removed, and they just get 25%. I'll do a whole video on it because most people don't actually know how it works, and that's fine. They're just not going to know unless you're in the industry. So the point is, okay, what happens is this: you only have attorneys who are underpaid in this field, horribly underpaid, judges who are also underpaid in this field, right? And basically legislators. Those are your three power groups that have high intelligence, usually doctorate level brains, figuring out, fixing the problem, fixing the issue, and getting you in a better spot. If you take away any one of these, then you're in a much worse spot than you were before with actually getting a solution from the Social Security Administration, who forcefully took your money all those years. How are they taking away attorneys? Well, they don't pay us enough, right? They don't pay the attorneys enough. It was so bad that they had to go ahead and increase the amount that they pay us over a short period of years, from $6,000 to $7,200, and then $7,200 to $9,200 in November, because attorneys were saying, F this field. It doesn't make sense. It doesn't make sense to have enough money to have staff to work on that claim. So what happened was attorneys just didn't do anything with the claims. That's what they were all doing. Like a lot of the big box firms, they were just, well, okay, we take on the claim. We have a receptionist speak with them all the time. If they want to get to an attorney, they got to go through 4 little levels of it just to even get to that person. They usually give up before that. That's how they did this field, because they got paid so little per claim. I know a lot of people have this thought that attorneys can just afford anything. Attorneys have to make a lot of money to employ all those staff members. And all those staff members have to do stuff. They have to go chase down medical records. They have to do, responses to SSA personnel. They have to do all that stuff, right? And then the attorney has to go to the hearings. The attorney has to prep you for the hearing with, testimony preparation and a bunch of other stuff, right? Check all the medical documentation, read through it, brief it, understand it, blah, blah, blah. But the reality is it's $6,000 after waiting and working on something and being with a client for, basically 3.5 years. I could not convince you to mop a floor, let's say once a month, for that amount of money over 3.5 years. I couldn't convince you of that. It just wouldn't make sense. Financially, it wouldn't make sense. The time it would take, if you had to mop that floor and it took you, let's say every month it took you, I don't know, let's say 5 hours, right? To get the whole thing done, do it right, blah, blah, blah. Yeah, I couldn't convince you to do it. You wouldn't do it, right? So the problem is, right off the bat, your 3 pillars of doctorate level brains, the lawyers were super underpaid. So they're not going to care or build the claim like they should be doing. And then, of course, there's the other issue too, which is now rampant in this field. And I mean absolutely rampant. Absolutely rampant. So Robert Platinum, it's supposed to be $10K based off of what the actual increases are over time. So they did the math. It was slightly over $10K that the attorneys were supposed to be getting paid at this point. So them raising it to $9,200, which is, basically a little bit, $800 and something dollars, shortchanging the disability attorneys. It's still insanity. It's still insane. Like, there's no other field where you get such a shitty deal with the amount of time spent representing somebody. But anyways, back to the other rampant thing that's going on in this field is that lawyers getting referral fees from other attorneys directly reduces the amount the attorney has to spend on the claim. So if somebody mass advertises, I'm gonna get my ass in trouble with this one. All right, but you should know. I mean, you should know. Whatever. So let's go through it. So if an attorney mass advertises, right? They're all over the airwaves. They're on all the billboards. If you call their firm and you have a claim that they do, right? They do that type of claim. But then you have another type of claim that they don't do. They refer that claim out to another law firm that then does a fee split with the law firm that you originally called in with, which means it reduces the amount of money that the attorney who's doing the actual work will get at the end of the day. Now, some fees, splits for referral, they're fine. It's like a small little token fee. It's not a big deal. It's, a little bit here, a little bit there. It's fine. But not with the big box firms, not with how they do it. They suck each other dry, but that creates that bond of them both feeling like they're actually financially winning by sending each other through this agreement claims. The reality is that they're not winning, because every time that they pay the other person, they're getting screwed with tax dollars. But again, they do this so that big companies can be sending money because they're referring, and then they get a referral fee back. Now, what does that mean for disability law? Well, it means an attorney that doesn't have much money to work on it to begin with is already getting less because they got the claim through another law firm that's advertising, and so they charge them basically a referral fee. There's another group that does this, and I'm gonna get in big trouble tonight. The other group that does this are the insurance companies. So the insurance companies basically will have a deal with some group, and that group will receive over the referrals from them. And then somewhere in there's usually some sort of kickback, some sort of relationship enjoyment, some sort of incentive. So a lot of people that go from, I got an LTD claim, my LTD carrier said I should go with this law firm. There's always one of those where there's a kickback or some sort of exchange or some sort of whatever that's going on there. Okay. Now, what does that mean? It means the attorney or the non-legal rep that's working with you cannot spend enough money to actually work the claim like it should be worked, because the SSA doesn't pay them enough, and the way they got the claimant requires them to pay a referral fee. So that's where it goes to shit. Okay. So that's the first of the three, to create a failure for you to end up getting your benefits that you probably paid in your entire life. So that's how they destroy the lawyers from being highly aggressive and successful with this field. Not to mention, if the attorneys try to really question the judges too much, right? And they go in front of these judges all the time. We go in front of the judges all the time because we have to do zillions of these claims. If we question those judges and we go after them and we file complaints against them, then that judge ain't going to approve our claims for the most part. And it's supposed to be neutral, and some of them are. But I know from practicing, and I know from hearing from the clerks and things like that, that there's always the tinge of a problem in the background when somebody complains. One of them I interned with, and that one, I had never seen such aggressive blackballing by the SSA when it came to that situation. I'd never seen it, which is, again, why I will never trust any entity, especially a government entity. Now, with that said, and no, even the government the government workers above all don't trust the government, because they know all the shit that they've done or the shit that their friends have done that they get away with. You know what I mean? So there is that. All right. So you got your three pillars right here, right? You've got your attorneys, how they weaken the attorneys in the Social Security Administration system. Now you have the politicians. This is how they weaken the politicians, because the politicians can't reach the judges now to get a response when they submit a congressional inquiry for people asking to fix a problem with the claim. So now it just goes to a hearing office manager. That's it. Boop, send it back. Done. Instead of having the actual adjudicator look at it and say, okay, what's the solution to this? How do we fix it? Okay. And sometimes the hearing office manager or managerial staff will have a fix that'll be in their side. It's an administrative fix as opposed to an adjudicator's fix. But you still want that judge to be required to look at it. You don't want to give that up. And it doesn't matter. You did give it up because they changed it without you even being able to vote on it. That's how that works. They just change things with you not voting on them. So that's how they weaken the politicians that have to do with basically the Social Security system. Now, the politicians can't reach the higher level intelligence individuals to go ahead and seek a solution related to code at the higher levels with these actual administrative law judges. Now, how do they weaken the administrative law judges? Well, the administrative law judges used to be trained by a totally separate group. Now they're trained basically by the Social Security Administration, through its subsidiaries. And with that said, if a judge approves too many claims, the rumor that seems to be pretty accurate is that they will go through retraining if they're approving too many claims. Now, do they have retraining for those who approve too few claims? I don't know. Guessing by how they usually do stuff, don't believe they do. I don't know that though. Do the judges have basically a lot of power, where they can reach this way or reach that way or do this or that? No. They have significantly limited the administrative law judge's power aggressively. They have empowered the commissioner of the SSA significantly and decreased the capacity of the judges adjudicating your claims so that they can't use a lot of variances to end up with a solution that will help you. Those days are over. They will never come back. All right. Why is this all relevant? Because A, you didn't vote to have your congressional leader, your senator and House rep, send something over to the SSA and have the SSA just have, basically a staff member sign off on what's going on with your claim. Next and done. You reached out to the senator so that the judge would take a look at it. That's why you did it. Okay. You didn't get to vote on this change. They did it anyways. So my point here is expect continuously, repetitively going forward that the SSA will, of course, create templates to expedite the processing of these things. Why are they doing that? It's because they don't have enough staff members, because your congressional leaders will not fund the SSA enough to properly process documentation. If they had enough judges, they wouldn't need this rule, would they? They just have the judges figure it out. You reach out to a senator writes the SSA, judge should respond. Not anymore. Not as of 7/19/23. So the point is, as a result of this change, the SSA is showing us as a general overview that they want to template organize your interaction with them, and that if you have a problem with them, it is less likely that you will actually have a solution without going through the long, drawn-out process. Okay? That's what this means. All right. Anyways, guys, I will catch you a little bit later. Please remember to like. Please remember to subscribe. I may be doing one more video. My voice is kind of going out a little bit. I will tell you this. A Category 4 or 3 or whatever hurricane is going to hit Central Florida. Most of my firm and all of the employees are based in Central Florida. We will be closed Wednesday. We will probably be closed Thursday. It's the line, just so you guys know, where it goes across Florida, like the accepted, average line where it's going to go, literally goes over my house. It goes directly over my house. So, and the office in Orlando. So the point, well, it's not directly over the office in Orlando, but the point is, just so you understand, on Wednesday, I'm going to get hit real bad. I am not going to have phone service in this area. They're going to give first responders that. I know that I'm probably going to need a FEMA. I know that FEMA is probably not going to be there when I need it. I know exactly why that is, which I'm not happy with, but it is what it is. I have a generator. It is not a standard like Generac attached to the house with an auto on. I don't have any of that shit. I have the one where you turn off the main power, you plug that in, you turn on that thing, and you hope it works. I have one of those setups. With that said, I will catch you guys a little bit later. Give me about 15 minutes. I might be back. If not, I went to bed. But sleep well. Please remember to like, subscribe. If you want to help me out, go to Google, type in Disability Resolution Law Firm or Disability Resolution Florida. throw some reviews up there. I always love seeing the stars. I will catch you either tomorrow, maybe tonight, but we'll go from there. Thank you so much. And thank you for being a part of learning what's actually going on, because so many people that head in the sand, you guys actually want to know. I'll catch you later. Thank you so much. All right. Bye-bye, everybody. Bye-bye.